Yeah, ZBM no bending. Color Z, that stupid motherfucking boss. Today, I just felt like breezing through and stopping by over at Jefferson University, having a seat underneath some shade. And today I just figured I'd take some time to study some of the legal things that I've been studying right here in the Eastern District. And one of the cases that I came across when I was reading through some of the books, the case name is the U.S. versus Mendoza-Trujillo, or something like that. Mendoza versus the U.S. One of the key words that we have here is called contravention. Contravention, right? I learned a new word. U.S. versus Mendoza. It's a Trujillo or something like that. I just want to talk about a few key pointers. It's a case based around Fourth Amendment rights and search and seizure and stuff like that. So I'm always interested in those cases right there. Kind of familiar with those cases. This guy right here, he actually had a suppression hearing. In the case file, in the docket, you can see that his suppression hearing was granted. So it was just a few key pointers. It was a lot, actually. It's actually a long transcript. And what is it? A long transcript and a long file. But I have 5 topic structures that I wanted to discuss. One being, witness status is not significant underneath the Fourth Amendment. So I'm looking more into that, but that was one of the key pointers, and it's like how he was able to win his suppression hearing. The second key pointer was, one of the second key pointers that I wrote down was, the length of a detention is significant to, prove whether or not it was like a lot of probable cause or whether or not it wasn't probable cause and whatnot. So the length of the detention is very significant. The third one that I wrote down was called, it's saying retention of identification is significant. So like the police, retain your information, your identification, all of that stuff is significant to whether or not, you'll be able to win a suppression motion or something of that sort. And then the fourth one that I got down was transportation has great significance, right? So this was interesting because I never really thought about this piece of, as far as like a Fourth Amendment argument or a search and seizure case or a traffic stop or anything of that sort. But I guess like in the case file, it was just describing how like the defendant was taken to the police station, but transportation has great significance. Defendant to police station, it plays a great part into whether or not he's being like detained unlawfully or if he's being seized, unlawfully, right? So if he's being coerced or something like that, promised something, or even if he's being forced to go to a police station. So the last one I got down is no circumstances between illegal seizure and consent forms constitute a discontinuity of arrest or search. So no circumstances between the illegal seizure or the legal stop. And then the gap between that and the consent forms, nothing that warrants the discontinuity of the longer the situation took. Is not warranted without something extra happening. So no circumstance between illegal seizure and consent forms constitutes a discontinuity of arrest or search. Stuff like that. But I was just, studying this case. It's actually a long case. It might take me way more time to really, be able to dissect more information from the law and everything like that and see how it was able to establish his suppression hearing getting granted. But the U.S. versus Mendoza-Trujillo, I think it's a good case to cite as far as Fourth Amendment rights and stuff like that, and even a suppression hearing. As a defense attorney, I think suppression hearings are very frequent and, very helpful to avoid trial, or maybe even for appeal case and stuff like that. So, no bending, Esquire Up.